What should I do if I had already been using my name for 10 years as a registered business and filed a trademark, but had to file extensions due to funds? So I assume that means perhaps limited funds. Meanwhile, two other companies in the same class filed similar names, and one of them took my labeling layout. What do I do? Let's talk about some of these terms here, because if a person is new to trademark law, you may not fully understand what all this means. So Chazzy's channel is saying, look, I wanted to register a federal trademark. We don't worry about state trademarks because federal trademark law trumps state trademark law. So I assume this is a federal trademark application. Once you file a federal trademark application, or as part of the filing, you need to show that you're actually using the mark in commerce. Why is that required? Because under constitutional law, the federal government doesn't have the authority to regulate trademark law unless it relates to interstate commerce. It's under the Commerce Clause. So as a legal requirement, federal statutes require that there be interstate commerce. Chazzy, I see your note here. You're classified as a 1B, which for those who are not familiar with trademark law, that means intent to use. So what Chazzy is saying is that rather than already using her mark in interstate commerce, she has said, I intend to use it, so I want to reserve a placeholder, essentially. And then what happens is she has a period of time, I think it's 6 months, to submit evidence, or a specimen is what it's called, but evidence that she's using the mark in interstate commerce. If she's not doing that yet, she can file for an extension and then another extension. There is a limit, but the extensions cost money and they take time. So first off, often my advice to business owners who are looking at doing an intent to use trademark is there any way that we can just get some commerce happening right now? For example, start selling to a few people. I don't care if it's your cousin or your uncle or your aunt, but get some sales done. Get a website out there offering it for sale. If there's a way to get some transactions and some advertising in place, that fulfills the very small requirement that you have some sort of commerce. But let's say it's not possible. For example, it's often not possible if you're going to sell a product that's patented, and you need to file a patent application, which means you also need to come up with a lot of money for the patent attorney fees to file the patent application. So you're not ready to sell it yet. Well, one option is you could start taking pre-orders. That might be a way to go. But just let's hypothetically assume that you can't. And so then you file the intent to use application. So back to Chazzy's question here. After filing the intent to use application, two other companies filed similar names. One of them took her labeling layout. So first, what are your trademark rights if you've been using a mark already in business? You have what's called common law trademark rights. That means you have a common law trademark in the counties where you have used the mark. It's not the same as a registered mark where you have nationwide rights or a monopoly on that mark, but you do have rights in the counties where you've been using it. Now, the fact that somebody else copied labeling layout makes me wonder if they are copying what you're doing. And if they are, that may be copyright infringement. If you have filed an intent to use application and then you provide specimens showing use in commerce, if the U.S. Trademark Office grants your application and so grants a trademark to you, that trademark is retroactive back to the date you originally filed it. So you would have a first in time, first in right situation. In other words, because you were first, you have first rights to use it. So in conclusion, if you find that once you start, or if you've been using a mark and then you apply for a trademark registration, the best option is to show that use and do a trademark application showing that you are currently using the mark. But if you must use an intent to use mark, then ultimately you want to get that finalized as soon as possible, because then it goes retroactive back to the date of filing if your trademark registration is granted. I'm Aaron Hall, an attorney for business owners and entrepreneurs, and I encourage everybody to subscribe at aaronhall.com/free. That's where you can get some exclusive videos helping business owners avoid common and expensive legal problems and help grow your company so you achieve success in your company and hopefully as well in your life.